An assist is usually a highly honored stat in sports, although its definition varies depending on that sport. For example, in basketball, an assist is awarded to the player who passes the ball to the player who scores. In soccer, it can be accidental, and in hockey, it can be more than one player. It can be two players. Okay, so that word and how it is defined is the focus of a Planned Parenthood lawsuit against Idaho's Attorney General Raul Labrador. The lawsuit was filed after a letter to the AG, or after a letter the AG wrote, I should say, to a member of the state legislature became public back in March. And that letter, which Mr. Labrador claimed wasn't an opinion, claimed Idaho doctors who refer patients for any out-of-state abortion procedure would be breaking the law. Planned Parenthood says that letter threatens doctors and violates the First Amendment's protection of free speech. Andrew Bartline, listen in on this hearing today. Andrew, so we want to know what both sides were arguing today, and was anything settled today?
Not exactly in terms of getting a definitive answer, but of course, those steps are now going in motion after hearing those arguments. The AG's office has to get some papers filed to the judge. Those are due Thursday. So at the very earliest, we'll see if this holds ground Friday or sometime next week for this lawsuit and those arguments. And to understand these claims fully, we have to follow along on a paper trail. And what's important, again, that word assist is taken specifically from Idaho's abortion laws and quoted directly by Mr. Labrador in that letter. So here's the original letter. It's from March this year. In it, Mr. Labrador explains to Representative Brent Crane, Idaho law prohibits an Idaho medical provider from either referring a woman across state lines to access abortion services or prescribing abortion pills for the woman to pick up across state lines. The AG arrives at this interpretation or opinion based on Idaho's abortion laws language, which says professional licenses should be suspended or withdrawn on multiple offenses for doctors who assist in performing or attempting to perform an abortion. So you catch that again, the word assist. The AG's office says referring a woman across state lines for an abortion would constitute an assist and therefore is illegal. That's the crux of this lawsuit that Planned Parenthood has filed against the AG's office. The lawsuit's a 20-page document, but it boils down to two things. Planned Parenthood says the AG's opinion violates free speech protections and it illegally aims to enforce Idaho's laws outside Idaho borders. But the larger problem here is that Idaho state legislature passed amendments to the state's abortion laws earlier this last session, I should say. Essentially, House Majority Leader Megan Blanksma sponsored a bill that changes how the prosecution works. It's the affirmative defense clause. Long story short, abortions in Idaho are considered innocent until proven guilty now. After Governor Little signed the bill, House Bill 374, the AG's office then released a second letter. It's an effort to take back what Mr. Labrador wrote in his first letter. The AG's office wrote in an email today, the law was enacted and the amendment of the existing statute by House Bill 374 vitiates the question of law. It renders the letter void. So none of this matters then, right? The law changed, the AG took back his opinion. Well, maybe not, because the language the AG used to justify his opinion in that original letter, that word assist, it's still in the new law. It's written exactly as it was in the original law. So if referring a woman to get an abortion was illegal before in the AG's mind, Planned Parenthood's asking, why would it change now if the language around an assist is unchanged itself? Planned Parenthood's attorney says the AG's office wants to have their cake and eat it too. They took back the letter, but they have not announced that the opinion in that letter was wrong, meaning they want to maintain those benefits of a chilling effect.
There was confusion after the initial letter was issued, and then there was even more confusion after it was purportedly withdrawn. And so the physicians that I've talked to besides our client, they don't know what to do, and that's scary for them. So we're really just looking for clarity here from the court.
The AG's office argued in return there's no threat and no grounds to sue the Attorney General's office because the AG does not specifically prosecute cases like this. It would be the individual county prosecutors, where the AG's office would typically offer assistance. Further, the AG's office says this letter was a personal and privileged communication, I guess attorney-client privilege
right.
with a member of the state legislature.
But isn't it also written in that law that the AG has the authority whether or not the county prosecutor is going to prosecute anybody in this case?
Sorry, say that one more time?
So in that law, there was a stipulation that the Attorney General could take on this case instead of relying on a county prosecutor to prosecute anybody who violates this law. Is that still in there?
I'm not exactly positive about that. That's actually something we should touch on at the end of the show. We'll check on that.
Okay, we'll check on that. That's one of the questions I had. I wish I'd asked you that earlier. All right, thank you very much, Andrew.